Hi, everybody. Thank you so much for joining us today in the Art of Estate Planning Facebook Live. Today's topic is Division 7A and estate planning, and I have brought in the tax specialists for this one, Daniel Taborsky and Lisa Monaco of Birchstone Tax Law, because this is a tricky topic. And if you're here going, Division 7A, where is that, which legislation, which state, I don't even know what you're talking about, then this is a session for you. So we're not trying to leave you as a tax specialist after this session. What we're really trying to do is bring some awareness to some of the trickier tax issues that can have an interplay with estate planning, so that you can identify that this might be an issue on your matter that you need to bring in the big guns. So speaking of the big guns, I'd like to introduce Daniel and hand over to him to tell us a little bit about Birchstone tax law, and then he'll also introduce Lisa more fully.
Great, thanks Tara. Yeah, so I'm from Birchstone Tax Law. We're a boutique specialist tax law firm over here in COVID-free WA. We started last year, and we've got a team of 8 now. One of which includes Lisa. I've got a background through like the big firms, EY, Greenwoods and Herbert Smith Freehills, and Lisa. Lisa, you can sort of explain your own background.
Yeah, I'm also from EY and previously HHG Legal Group as well, and I've worked in regional WA.
Great. So Tara, we got some slides. So if you're happy, we'll sort of work through some slides. But very happy for either you or anyone watching to sort of jump into questions, and very happy to go off topic and address what's of interest to the people.
Yeah, that would be fabulous. And just for everybody who is viewing this, particularly if you're on your phone, Daniel and Lisa have kindly agreed to make the slides available after the presentation. So we'll get them up in there if you do want to refer back to the slides as some notes, so you don't have to scribble everything down furiously or try and zoom in to your tiny screen. We'll have the notes available. And feel free to ask questions as always. And Daniel and Lisa will just make sure there's time at the end to answer questions. And also, if things are relevant as they're going through and not going to disturb the flow of their presentation, we'll try and make sure that we answer them at the same time. So Daniel and Lisa have been very generous with their time, so take advantage of it and ask your Division 7A UPE loan tax questions. Over to you, Lisa.
Great. I will. So what we're going to go through is we're going to do like a 101 on Div 7A. So we'll start assuming you know nothing about Div 7A, and then sort of go into some more advanced topics, if only for awareness, rather than, as Tara said, not trying to make you tax experts in this presentation. Then Lisa will talk about some interactions around Div 7A and estate planning and death. So we've got a few different examples to run through there. And then I'll finish off and tell you why everything I've just told you is about to change, or will change at some stage in the future with these proposed reforms that have been in the works for quite a while. We'll finish on that. So Div 7, as Tara said, this is Div 7A. It's if you want to go to the legislation, it's in the 1936 Income Tax Assessment Act. And I think the best way to start with Div 7A is to sort of understand what the purpose of Div 7A is. And it's all based around these numbers. So it's really, on the left we have the corporate tax rate, which is now 26% for your small businesses. And on the right you have the highest personal marginal tax rate. And Div 7A is all about shareholders or associates using funds that are being taxed at the company rate, so 26%, but have not paid what we call the top-up tax to bring them up to their personal income tax rate. So if corporate tax rate and the highest marginal tax rate for individuals were the same, there'd be no need for Div 7A. Div 7A only exists because there is a difference between the company and the personal tax rates. And I mean, often I get this, and I assume you probably get this as well, Tara, but clients go, well, it's my company, it's my money, why can't I use the money for whatever I want? And you need to be able to convince your clients that the company's money is not their money. It's the company's money. They've set up a company for a reason, and they can't just go in and take the company money without there being consequences for that. So yeah, that's a good one for clients trying to get their head around that the company's money is not their money. And so
Daniel, it's often SMEs, like mum and pop businesses, who are the main clients who run into strife with this, isn't it?
Yeah, absolutely. So it really is it's a private company type thing. So it's not for your big sort of ASX listed companies, but you can have some quite large private groups. And we'll go through the base model, which is I guess relatively simple, although still complicated. But then once you start bringing related entities and trusts and other types of entities in the group, it goes to a next level Div 7A. So what used, I guess, if you can go right back, what used to be happening before Div 7A or its predecessor got introduced is that companies would earn profits, they'd pay tax, and they would sort of loan money to shareholders and associates, and those loans would be generally interest-free, at call, no repayments required, and probably won't be repaid at any stage, and maybe forgiven. And that was a way of getting basically funds that were taxed at the company tax rate out to individuals for their enjoyment without paying top-up tax. So Div 7A was brought in to sort of address that issue, and we'll have a look at how Div 7A can apply. I've called this a direct model. This is kind of like the base case, and it applies to transactions between a private company and a shareholder of that company or an associate of that shareholder. And it can apply to either payments the company makes to the shareholder or the associate. It includes the use of assets. So if a company allows a shareholder to use an asset, Div 7A can apply to that as well. So a common example there is either the company has a holiday house and it then allows the shareholders to stay there rent-free. That's a Div 7A issue. If the company has a boat, the family yacht, and the company allows the shareholder or associate to use that yacht without paying any tax, that's also a Div 7A issue. So that's payments, and yeah, payments can also include like payments of cash, but it can also include the transfer of assets. So again, transferring an asset out of a company to a shareholder, that can trigger Div 7A. We then have loans that a company may make to a shareholder. So if a company lends money to a shareholder or associate, Div 7A can apply to that. And look, there are some exceptions that we'll come to in a moment. But yeah, loans are prima facie caught. And the last one is debts that's owed by a shareholder to a company, and the company then forgives that debt. That again can trigger a Div 7A issue. Now, just a few points on that. Associate, when I talk about a shareholder or an associate, I think it's probably reasonable to assume within private groups, an associate's going to be basically anyone related or connected with that family. It's a very, very broad term. I think the starting point that should be anyone that's related to that shareholder will be caught by these rules. And we're not just also, a common misconception is that Div 7A is only concerned with payments, loans, or debts forgiven between a company and like an individual or a human. That's not the case. It can equally apply to payments, loans, and debts forgiven between a private company and a trust. So yeah, often that's a misconception that it has to be to an individual. It does not. A trust can be the recipient of a Div 7A deemed dividend. And so I guess that's the next thing. What are the consequences if Div 7A applies? Now, as I've got on the slide here, it's a deemed unfranked dividend. So if a private company makes a You can see my mouse there. If a private company makes a payment or a loan to a shareholder or associate, and that doesn't comply with, for example, the loan rules we're about to go through, that will be a deemed unfranked dividend from the private company to the shareholder or associate. So just to put some numbers around that, the private company is would have paid tax on those profits at 30% or 26% under the current base rate entity rules. That then gets taxed at the individual level again at another, if they're on the top marginal tax rate, 47%. That could be a cumulative tax of more than 60% across the two entities, which is it's a huge cost. So you really don't want Div 7A to apply. It's really not a good outcome for the client. So some exceptions. So prima facie payments from a company to a shareholder associate of court, but if the shareholder associate has paid a market value consideration for that asset or for the property that was transferred out, or has paid market value sort of rent to use a holiday house or to use a yacht, that's an exception for Div 7A. So when there's a market value consideration, money's going back into the company for the use or the asset that's coming out, Div 7A won't apply in those situations. The most common exception you'll see is for loans. So where there's a loan from a company to a shareholder, and that loan is put on what we call sort of complying loan terms, or you may have heard they sometimes refer to the section in the Act, so Section 109N. If the loans are on those terms, Div 7A won't apply to the making of the loan, and so that's either a 7-year loan if the loan is unsecured, or if you have security and you can grant a mortgage over real property of sufficient value, then you can extend the loan out to 25 years. So that when you've got a complying loan agreement in place, the making of the loan won't give rise to a deemed dividend because you comply with the loan terms. There's then an obligation on to make repayments each year in accordance with the loan agreement, and as long as you make repayments each year, Div 7A won't apply at all. But if one of those years or multiple years you fail to make the repayment, then Div 7A will apply for the amount of the repayment you fail to make. And often, I guess, as a practical way of doing this, what happens is, the money comes out, gets lent out to the individual, the shareholder, and then a loan agreement is put in place, and then in subsequent years, the company will then declare a dividend to the shareholder, and that dividend will be used to offset the loan. So the shareholder owes the company money for the loan, the company owes the money for the dividend, and those two amounts are set off to meet the loan repayments each year. So in practice, if you're looking through, your accounts and you can see these dividends and the loan balance going down, that's often how accountants will deal with these Div 7A loans year to year. Some other exceptions around like company-to-company transfers, they're excluded. As we said right back to the start, Div 7A is concerned with funds exiting the corporate tax environment. If it's a company-to-company transaction, no real mischief. There's some rules around insufficient or no distributable surplus. Not really going to go into them in too much detail today, but that is potentially some other way you might be able to get out. And the last sort of exception I'll talk about is where Div 7A has operated through the rules we've just gone through. There is a commissioner for the ATO to either allow that deemed dividend to be disregarded or to allow the dividend to be franked. And the main condition around that is that the deemed dividend must have resulted from an honest mistake or inadvertent omission. So often you might get a client that's had they've been poorly advised, or they've just been ignorant of Div 7A, and Div 7A is operated without their sort of knowledge to cause deemed dividends. In some cases, we can go to the commissioner and ask for his discretion to disregard those deemed dividends for prior years. Tara, have we got any questions at this point?
Yes, Daniel, we have. So Joseph has asked, Does Division 7A apply to sole traders, or is it only to proprietary limited companies?
Yeah, so good question. Yeah, there needs to be a company. If there's no company in the picture, Div 7A won't apply. So if it's purely a sole trader, don't need to worry about Div 7A.
Yeah, and that's because when we go back to what you said at the beginning with the purpose, the sole trader is already paying their marginal rate on the income they're earning from the business, right? So there's no need for a top-up tax rate, or they're not getting a discount on the use of those business funds, which can happen when they're trading through a company. That's how I always like to think about it, because otherwise, like, yeah, you'd like try to remember all these rules and it can do your head in. So I always go, well, what's the point? Like, what are they getting a tax advantage by having these funds or payments being made?
Exactly. It's all around avoiding that top-up tax, the difference between the company tax rate and the individual tax rate. If there's no company in the picture, obviously you can't. There's no avoidance there. You've paid tax in the first place at your individual tax rate.
Joseph, I hope that's answered your question. If it hasn't, just tell us in the comments, and we will do our best to answer it for you.
Great. So just going back to what we've looked at before, these have all been transactions directly between a company and the shareholder or the associate. That's what I call the direct or the base case. We're now going to go somewhere that starts getting a little bit more complicated, if that wasn't complicated enough for you. In this case, we have a trust, and we can see there's a trust, and the trust has made a company presently entitled to income. So each year, the way the taxation rules work, it creates an incentive for a trust. If a trust has derived income, it has to make the beneficiaries of that income presently entitled to a share of that income. So all the income gets distributed to beneficiaries, or at least they're made entitled to that income. Where a trust has made a company entitled to the income, and that income has not been paid, so you have what's called an unpaid present entitlement, or a UPE, Div 7A can then apply to payments, loans, and debts forgiven from a trust in a similar way to how it applies to companies. So even though in this case you've had the trust that's made a UPE to the private company, the trust then makes a loan to the shareholder, and even though that loan isn't coming from the company, because this UPE is in existence, Div 7A can operate to deem that loan to be an unfranked dividend between the private company and the shareholder. And so that confuses a lot of people. What you really need to be looking out for on the balance sheet is if there is a trust that has a UPE to a company, you then have to be alive to any Div 7A issues that could be enlivened by this sort of UPE model. And what you might see in some of the financials is you might see, well, there might be UPE to a company. I've blocked out the company name here. Or you might see, you commonly see this pre-16 December 2009. Now that's a very relevant date. And to try and explain this simply, there was before 16 December 2009, the ATO considered that a UPE was not a loan for Div 7A. So the purely making of the trust making this UPE to a company, this transaction by itself didn't trigger Div 7A. But then if the trust then made loans or payments to shareholders, that second transaction would trigger Div 7A. From 2009, the ATO changed its view. So it now considers that a UPE that a trust makes to a private company will, unless things are done to prevent it, will be a loan. That's now, the ATO now considers that is a loan from the private companies to the trust. So the way you can sort of get your head around this is the trust has made the company entitled to money. The company hasn't called for that money. So it's in effect as if the company has lent that money. You can consider it as if the trust has paid the money to the company and the company has then lent it back. So it's not a legal loan under ordinary legal principles, but for Div 7A has a sort of expansive definition of what a loan is. This UPE, post 2009, the ATO considers is a loan. So merely this transaction by itself, after 2009, will give rise to Div 7A consequences, because as we said, if a company makes a loan to a shareholder associate, so assuming the trust is a shareholder associate, which 99 times out of 100 it will be, that loan from the trust, from the company to the trust, will give rise to Div 7A implications unless it is put on the complying loan terms, or in this context, the ATO allows, you might have heard to subtrusts, if the UP is held in a subtrust. So it's like a sort of, it's held specifically for the corporate beneficiary, so it's separated from the other assets. It's held specifically for that private company. The private company gets a return on the UPE. If it's put in this, what they call subtrust, then that UPE won't give rise to a loan. So I've probably confused everyone completely here, but a change in 2009, from 2009, this UPE will generally be considered a loan, and most people put these on complying loan terms. Pre-2009, the UPE isn't considered a loan, but then you have to worry about these loans and payments that are going out to individuals or other trusts. And a common way you might see that in the accounts is...
And Daniel, this is the trust balance sheet that we're looking at, not the company balance sheet.
Yeah,
right?
Exactly, Tara. Yeah, very true. So this is a trust balance sheet here, and these are all the unpaid trust distributions. This one here, this fourth one down here, this is to an individual, and you can see here. So when it's positive, that's money that the trust owes the beneficiary. But these amounts here, these are negative amounts. The net balance is negative, $1 million. And so that's money that's in excess of the entitlements the beneficiary has been entitled to. The beneficiary has been paid more than that. And at law, that's generally we consider that as a loan from the trust to the beneficiary. It's in excess of its entitlements. It's a loan from the trust to the beneficiary. And if that occurs and there is a UPE between the trust and the company, Div 7A can apply to that case. Now, Tara, I think we've had a question come through.
We have. Can you see that?
I can see it. Yeah. So, is the UPE from the trust to the company a distribution? Is Div 7A triggered still? Is Div 7A still triggered if the distributions are made to the PTO as well as other beneficiaries of the trust? Yeah. So that, going back to the diagram here, that is a distribution, but it has not been paid. So they may have made distributions to other beneficiaries. That's kind of irrelevant whether it's gone to other beneficiaries or not. As long as there has been a distribution that has gone to the private company and that distribution remains unpaid, then Div 7A can apply. If it's been paid across, so you've made say the trust has $100 of income, it's distributed that income to the private company, and that $100 has been paid to the private company, no need to worry about Div 7A. There's no UPE in existence, there's no loan. It's only when the trust makes the UPE, makes the company entitled to the $100 but doesn't pay it and remains outstanding, that's when Div 7A can apply. And to try and step back to like the purpose idea, if you've had the trust has made $100, it's made the company entitled to it, and the company then pays tax on that at the corporate tax rate, so 26%. If it then lends the money to the shareholder, whose marginal tax rate's at 45 or 47%, then you've got a tax benefit because you've made the company entitled to the money, and the company's paid tax on it at 26%. But the benefit of those funds have gone to the shareholder of the company, who should have paid tax at 45%. So that's really the mischief this is trying to get to. But when you get into the detail of the rules, you kind of lose sense of what the purpose is. But that, going back to a simple example, that's really what it's trying to tackle.
And Daniel, it became a problem, and this 2009 sort of line in the sand became a problem because historically people always would distribute their income from the trust to a company, because one, trusts have to distribute their income every year, unlike a company. Remember, trusts are flow-through vehicles for tax purposes. So every year you have to distribute the income out or else you pay the top marginal rate in the trustee's hands. So there was this very common practice of, well, we'll just set up a company that really doesn't do anything, like a bucket company or a corporate beneficiary, and we'll just distribute to that company and cap our tax on that income at the lower tax rate, but we'll keep the money in the trust as like our business working capital, rather than paying it through. And that was a totally acceptable practice before 2009. And then the government sort of changed the rules, which has then created this complication with the Division 7A and the post-2009. So if you might be going, well, why would anyone enter into such a complex arrangement? That's why, because it was a really simple way to kind of manage the tax, but also keep the money in the trust, because then these small businesses often needed the profits to keep in the working capital for the business.
Yeah, and so that's a big, post 2009, you don't even need this loan out to the shareholders. The mere fact that those funds have been retained in the trust for working capital is enough to trigger Div 7A post 2009. And so if you have a business that's in a trust that has extensive needs for working capital and needs to retain funds, it's very difficult to try to manage with the trust as being the operating entity. There's really now a great incentive to try and convert that trust business into a corporate entity, where the company is actually running the business itself, so those funds can be retained. Just get another question come through.
Can I just check, Daniel? So if we just had the trust making a loan to a shareholder and there wasn't a loan or a UPE to the private company, and assuming we're not dealing with inter-entity trust to trust, like there's not another trust with a loan to a private company. If you just took out the private company here and it was just a discretionary trust making a loan or an unpaid present entitlement to an individual, and there's no other companies in the group, we don't have to worry about Division 7A, right? It's the presence of that company that gets us into the risky zone.
Exactly, 100%, Tara. Yeah, look, there may be other issues with that, but Div 7A is not one of those issues. You need a company for there to be Div 7A. Yeah.
Okay.
So the other question, to get around Div 7A, can the trust distribute to the company, then the company loan back to the trusts if the trust requires the funds as working capital? It can definitely do that, but then you've got a loan between a company and a shareholder or associate of that company, which almost always a trust is going to be. So you're back in the base case. You've got a company lending money to a shareholder or associate. Those loans have to be put on compliant Div 7A terms. So either a 7 or 25-year loan, and repayments have to be made across those 7 and 25 years. And on an ongoing basis, that's generally not sustainable for a trust that needs extensive working capital. So that's...
So the short answer is no.
No, yes.
And I mean, that's been my experience, Daniel. I mean, it's a very expansive legislation. There's not a lot you can do to be clever or tricky to avoid the operation of the legislation, other than pay out your loans, pay out your distributions, or get on a compliant loan agreement and comply with it.
Yeah, or restructure the trust into the operating trust into an operating company is really the only long-term solution that's going to work here if your trust needs to retain working capital. Okay, so we've gone for the UPE. Now to go one further, and one last sort of issue is kind of around, as Tara was saying, you can have interposed entities here. So this is just one example of these interposed entity rules. So in this example, we've got a private company, and there's a family trust as a shareholder of that company, and then the family trust has at least two beneficiaries. You've got Mr. S and Mrs. T, and Mrs. T is a non-resident for income tax purposes. And nor are they. They're not spouses in this case. They're unrelated parties, or at least not related, not married. And so in this case, you've got the private company. The company pays the dividend to the trust. Okay, very vanilla stuff here. Company pays a dividend to the trust shareholder. Nothing unusual about that. And then the trust, and this could happen in either order, but on this facts that the trust then lends the money interest-free to Mr. S. And I think we can assume Mr. S is on the top marginal tax rate. So if he was to be made entitled to the income, he'd be paying tax at 47%. But instead of being made entitled to the income, the trust lends the money to Mr. S, so he pays no money, no tax on that loan. And instead, the S family trust makes Mrs. T a non-resident presently entitled to the income, but doesn't pay it because the cash has gone to Mr. S, but Mrs. T is being made entitled to the income. And because she's a non-resident, and we're dealing with a fully franked dividend, she pays no further tax. If instead the S family trust made Mr. S entitled to the income, because it's on the top marginal tax rate, he would be paying tax at 47%. So there's been a tax saving there. You've got 30% instead of 47%, yet Mr. S has still enjoyed the funds. So in this case, even though we're talking again about loans to individuals from a trust, and in this case there is no UPE here owing to a trust, but Div 7A can say, well, if when the company made the dividend here, made this initial frank dividend to the trust, if that was part of a scheme or arrangement whereby these funds would go tax-free to Mr. S, then we can basically disregard the trust and consider it as if the company had lent the money to Mr. S. You've got a notional loan for Div 7A purposes, and then unless that loan is put on compliant loan terms agreements, so you get your 7 or 25-year loan, Div 7A could apply to deem a dividend from the private company to Mr. S. So that's just how expansive Div 7A can be. You've got a very commercial transaction here, fully franked dividend from the trust, but because of some potential dodgy stuff that's going on here at the trust level, Div 7A can apply to deem a dividend.
Daniel, if Mr. S and Mrs. T were associates, or let's say they were married, would that make a difference?
Yeah, when this was initially in a tax determination or tax ruling that came out a couple of years ago, in the draft they just had this example, and I'm not sure they were explicit in the first draft whether they were married or not. They then brought in a second. When they finalised the ruling, there was an additional example which had, if these people were married, the ATO would consider this wasn't part of a scheme to disregard, Div 7A. So yeah, if they were married, that probably would make a difference. But it's potentially extremely broad, because this would happen not infrequently, where you have maybe the adult kids being made entitled to income, but the benefit may be going to the parents. So the ATO, I think it's a grey area, but the ATO, there is some comfort in the final ruling that came out that said these transactions between spouses won't necessarily be caught by Div 7A. Okay, I think that's all I was going to say. Is kind of like a very long introduction to a basic 101 on Div 7A. If there's no other questions, I might hand over to Lisa to talk about some interactions with death.
I think we've covered all the questions. So if there's any more for Daniel, we can answer them at the end, just so that in the interest of time, that Lisa has enough time to cover her topic.
Thanks, Dan. Thanks, Tara. Okay, so the crossover zone between Division 7A and death is one where there's not a lot of guidance happening. But taking it back to the beginning, the death of the borrower, their executor will assume the borrower's liability. And the executor will basically have the three options of what to do with that liability. They can repay the loan, they can do nothing, or they can approach the company to forgive the debt. So we're going to spend a bit more time on doing nothing and the company forgiving the debt and the kinds of issues that will bring up. Next
Yeah,
slide,
because
please, Dan.
obviously, Lisa, if you repay the loan either in full or in accordance with the loan agreement, you've complied with Div 7A, there's no issues with repaying the loan. So that's the easiest way forward.
But I guess we should, Lisa, there is just a big sort of statement saying death doesn't actually make Division 7A go away, does it?
Exactly.
It's not like, oh, the borrower's dead, Division 7A obligations end, have a holiday, like a tax holiday. Like the obligations endure, which I think is probably for the estate planning lawyers who aren't sort of across this from a tax perspective, that's probably the takeaway, isn't it? You have to know about this, and death could create more issues, particularly in an estate administration context, or hopefully we can get ahead of it in a planning context as well.
Exactly. So it's really the way that the debt is handled if the borrower passes away. So something that probably comes up fairly often is where the executor fails to make the minimum repayments under the complying loan agreement. And this could happen for a number of very genuine reasons. Maybe the executor didn't know that the agreement was in place, or that there was a payment due, or even they didn't have the cash funds available to meet that minimum repayment. So this one could come up quite a lot. The guidance we have on this comes from ATO ID 2002-741, and that case looked at this exact scenario where the executor didn't make the minimum repayments required under the agreement. And so on the facts of that case, the conclusion was that there was no deemed dividend under Division 7A. And that was really because the wording of the section in Div 7A that was relevant to this focused mostly on the entity to whom the loan was made, which in this case was the deceased shareholder. And that entity was a different entity to the executor who would be dealing with that deemed dividend. So because of that mismatch or disconnect, the section didn't operate to deem a dividend. So that was a good outcome there. However, it could be that if after the person's death, the executor gets a loan or a payment from the company, then that could result in a deemed dividend for the executor. So there's still something to be careful of there. But let's take a closer look at the facts of that ATO ID that I just mentioned. So this was a scenario where in the 97-98 income year, a company made a loan to the shareholder, a complying loan agreement was in place, and everything was set up really well. However, in the following year, 98 and 99, the shareholder passed away. And at that point, the shareholder hadn't made any repayments. There were no repayments due under the agreement. But as time ticked on in the following years, repayments were due, and the executor didn't make them. And so this is the set of facts that the ATO was looking at while analysing the section and finding that there wasn't that connection needed for the section to deem a dividend. So basically, this case gives us a bit of confidence that if we've got a situation where someone's passed away and they've got repayments due, failure to meet those repayments isn't going to cause an issue for Division 7A. Can I have the next slide, please, Dan? Thanks. Now, the other thing about death is that it seems to trigger a lot of waves of forgiveness. And so one option open to the executor is to ask the company to forgive the debt. However, that could cause some issues because that was the exact scenario that we looked at in ATO ID 2012/77. And in that case, it was concluded that there would be a Division 7A issue. And we'll look at the facts of that case in just a moment. But it is interesting to note that subsequent to that decision, there are a number of other private rulings in the following years that had the opposite conclusion, that there was no deemed dividend. And the difference we're seeing between those three private rulings and this ATO ID was really timing, whether the forgiveness occurred before or after the grant of probate. So we'll look at the facts of ATO ID 2012/77, and I'll explain a little bit more why that was the case and why timing was so important. Okay, so in this scenario, what we had was a loan made in 2008 to 2009 income year. The shareholder died some years later. Everything prior to that had gone as normal. There was a complying loan agreement in place. Repayments were being made. No issues. But then following the death, the executor appointed under the will went off to get probate, and the executor got probate in that same income year. And then by the following income year, the company forgave the loan. And that caused quite a big issue for the executor. And the reasoning in this case was very much because it was based in New South Wales. There was a provision in the Probate and Administration Act that said that once probate was granted, then the assets of the deceased would vest in the executor retrospective to that person's death. And I'm sure other states have very similar provisions as well. And so the effect of that meant that when the ATO looked at the actual terms of the section in Division 7A that was relevant, the person responsible for the debt was the executor, even though the deceased had passed. Probate was granted, and so the executor was effectively stepping in the deceased's shoes and was responsible for that debt and was also the relevant shareholder. So in that set of circumstances, all the ducks aligned, and basically it resulted in a deemed dividend for the executor.
And Lisa, that point around probate is, I find that quite interesting, and seems to be potentially in certain jurisdictions quite a bit of a loophole. So I think those private rulings that considered forgiving a debt before probate, I think they're all based on the New South Wales legislation. And probably the estate planning lawyers can probably speak to this better than I can. But in New South Wales, until probate's been granted, or it's only from when probate is granted that the executor is deemed to assume the liabilities of the deceased. I think in some other jurisdictions, it's once probate is granted, the executor is sort of retrospectively deemed to have assumed the liabilities from the date of death.
That's right.
In those other jurisdictions, this potential loophole of being able to forgive a loan before probate is granted without there being a Div 7A implication, I don't think really exists. But in New South Wales, I'm not sure what other states are like New South Wales, if any. There may indeed be a bit of a loophole there. And there's obviously been a few private rulings, probably not the kind of thing you want to do without a private ruling, because the consequences of getting it wrong are quite significant, but there may, in New South Wales, be a bit of an opportunity there. Now, there was a... Sorry, Tara?
Can I just ask or make a statement and a question, I think, before we just go back to that question about 2002/741. So who's doing the forgiving? It is the directors of the company?
Correct, yes.
That's right.
Yeah.
Yeah, okay. I mean, this scares me, this forgiveness issue, right? Because the forgiveness, or the if you add alive to the Division 7A issues, this deemed dividend that can arise on the forgiveness may not come to light until several years after even the estate is administered, right? Because the ATO has a lengthy audit period. What is it? Is it like 4 years?
Yeah, for taxpayers with complicated affairs, 4 years. Yeah,
4
from
years.
when the return or assessment was issued. It's not the end of the income year. You've got to work out when the return or assessment was actually issued, which could be even almost a year after, even if it was within time, and longer if it was lodged late.
Okay, so we've got an executor who is liable for the tax debts of the taxpayer, and they may, and obviously they can be reimbursed from the assets in the estate, but they may have distributed the estate. They probably will have distributed the estate by then. And then the ATO can come back and say, actually, there's a Division 7A problem, there's a deemed dividend, and these individual executors are personally liable. Is that how it works?
Yeah, absolutely. Yeah, and it's not just things that happen. Yeah, it's not just things that happen while the executor is in place. It could be stuff that happened before the deceased passed away. For their tax returns prior to death. Yeah, so potentially very broad.
I was at a conference last year with the Tax Institute, and one of the topics was basically who would be an executor these days. Like, the tax risk is immense if you don't have everything done. So that, I mean, I just wanted to sort of connect the dots there from a practical perspective, particularly for the estate administration solicitors who may not get why this is such a big deal.
Yeah, and there was, Tara, just on that, there was a, I think it was a practical compliance guideline that came out a couple of years ago around giving executors some sort of comfort around prior tax losses, but it's very narrow in its application. Yeah, so you'd have to, if you're going to be relying on that, you've got to be making sure you're 100% confident that you fall within the facts of that guidance from the ATO.
Yeah. And Joseph has asked a question, and it was actually, I was also asking it in my head as well, in the fact that, because I was like, oh, well, we've got ATO ID 2002/741, potentially you can just ignore the Division 7A consequences if you don't do anything about it. Is that right, Lisa? So me sort of saying it doesn't go away, well, it kind of could go away if you did nothing.
So that first ATO ID that we looked at was more about loans, and so the debt still exists. It's just that you're not triggering a deemed dividend, but obviously an estate debt is an estate debt, and it needs to be dealt with. But in terms of repayments, failure to repay or do nothing for the immediate future isn't going to have a Div 7A issue for you. With this current ATO ID that we're looking at, this is more about loan forgiveness, and in that case it's going to be the timing of what the executor does that's going to either trigger or not trigger an issue there.
Yeah, so you can defer the tax consequences. You can just do nothing for a period of time, but at some stage the loan is either going to have to be repaid or it's going to be forgiven, and if it gets forgiven, then the Div 7A implication is going to hit at that time.
Okay, because you can't actually wind up the estate administration without addressing that debt.
Yeah.
Got it.
Yeah. Do nothing was more like, don't worry about meeting repayments in the, as and when they fall due.
Yeah. Okay.
Okay. We'll just move on to the next slide.
Do you want to deal with that question, which I think we probably have just dealt with it? Yeah, that really is. Yeah. Does this mean if that forgive before probate, no Div 7A issues? If debt forgiven after probate, there are Div 7A issues. Definitely after probate, there is Div 7A issues. Before probate, in New South Wales and other states that have similar legislation, which I don't know if there are any, or which ones they are, there may be an opportunity, but definitely something you don't want to do without getting advice and potentially even a ruling from the ATO on.
Yes, I hope the overriding message people are getting from this, Daniel and Lisa, is get advice. You can't wing this.
As I said, the consequences are a deemed unfranked dividends for potentially the amount of the loan. That's like a significant tax cost to the estate if that's what the outcome is. And if you're the executor and potentially personally liable, not something you really want to be exposed to.
Okay, and I just wanted to make a couple of comments on insolvent estates as well in this context. So there are some circumstances where forgiving a loan won't result in a Division 7A issue because either the estate is bankrupt or because the repayment of the loan would cause the estate undue hardship. So in those circumstances, the loan can be forgiven without any deemed dividend.
Yeah, which makes sense. Like if the estate is bankrupt, which I've been involved with before, those loans are going to get written off due to bankruptcy, and Div 7A won't apply in those circumstances. Thanks, Lisa. That was great. There's other sort of peculiar interactions between Div 7A and kind of deceased estates that we haven't gone through and get very. I mean, it's very great. It's a very grey area because apart from these two ATIDs we've gone through, there's really no ATO guidance on this. So there's other potential loopholes for payments that are made to the deceased in the year of death. There's arguments that Div 7A doesn't apply to that. That's not a tax planning strategy to make a big payment to someone while they're on their last legs. But potentially, if it happens to be a payment made in the year of death, there's potentially the rules in Div 7A deficient to capture that. It's just a very unclear area around sort of deceased estates and Div 7A. Now, just conscious of time, I just wanted to sort of touch on these sort of proposed changes to Div 7A. Kind of everything we've told you up to now may well be changing, and they have kind of these changes have their genesis back to 2012 with a border tax review that commenced back then, and there's been a border tax review and they gave a report, and then the government came out with an exposure draft back in 2018, and these changes are supposed to take effect from 1 July 2018, got pushed to 2019, got pushed to 1 July 2020, and on 30 June 2020 here, this year the government said, well, we're going to defer it. We're still going to progress with these changes, but we're going to defer them until the year after the legislation goes through Parliament and gets royal assent. So we don't have a date now when it's going to apply, but they still are definitely on the cards. There's a number of different changes. The main ones are dealing with loans and UPEs, so I will just touch on those quickly. So for the loans, the current so we've talked about what pre-09 UPEs. The other relevant date for Div 7A is just sort of 4 December 1997, and you may well see pre-97 loans. And that's because Div 7A got introduced in 97. So loans before then are effectively quarantined. And so when you're looking through the financial statements of companies, you may see pre-97 loans, and the accountants will be, they just don't touch them. They just stay there. Nothing happens to them. They've been quarantined for Div 7A. Everyone's too scared to refresh them. They just sit there. But under the proposed laws, these quarantine loans that currently aren't subject to Div 7A, which are potentially quite significant, the proposal was that they be brought into Div 7A with a 10-year loan, and had to be repaid over 10 years. So that's scary. Yeah, that's scary. And then there's a whole sort of argument around, well, have the loans been forgiven due to becoming statute barred? In which case maybe there is no loan anymore, and the Div 7A implication should have arisen X number of years ago that are outside the ATO's amendment period. There's a whole bunch of complicated arguments around there that if these get brought in, people will be looking at. So they're the pre-97 loans. For our standard loans that, as we said, normally have to be at 7 or 25 years, those 7 and 25-year loans are going to disappear, and we're only going to have 10-year loans going forward. And at the moment, the interest rate that has to be paid on those loans is based on like a home loan interest rate. So back in 09, that was 5.2%. The new rates is based on the small business overdraft rate, so it's about 3% higher. So your cost to maintain these Div 7A loans is going to get even more expensive. Because often Div 7A is often used as a tax planning strategy. So instead of paying a dividend out, we'll loan the money and then pay dividends in subsequent years to spread the tax. The benefit of doing that is going to be eroded with this higher interest rate. So they're the changes at a high level to the loans. To the UPEs, again, we have the pre-16 December 09 loans. At the moment, they're not treated as loans, but you have these sort of interposed entity rules where if you have the trust making payments out to a company or shareholder, they could be called by these EA/EB, which are those sort of interposed entity rules. The discussion paper said nothing about, or raised the question, what should happen with these loans? The fear is that, like the pre-97 loans, the pre-09 UPEs are going to be brought into Div 7A and need to be repaid. And some of these numbers are just scary. Like, I've seen numbers like hundreds of millions of pre-09 UPEs that are going to have, if they get brought in, I'm just not sure how they're going to be able to be repaid.
I was going to ask Daniel, what was the biggest pre-97 loan that you've come across?
Probably in the hundreds of millions as well.
Ones.
Like they're enormous ones. Yeah. Generally, I find the pre-09 ones are probably larger because the pre-97 ones have generally, as a general rule, been used for private benefits. So there's only so much you can spend on holidays and houses and the like. But these pre-09 ones have often been used for working capital. And so those monies have been retained by the business, put into assets. A lot of that money may have been lost, like GFC and now COVID. A lot of those asset values may be reduced. The money might just not be there to be able to repay these UPEs now. So it's going to be a big issue if they get brought in. But some really, really scary numbers in the pre-09 and pre-97 loan space. For UPEs going forward, they're going to amend the law to just say that any UPEs to private companies or to bucket companies will now be just treated as a 10-year loan. They're just going to be a loan. There's not going to be no argument. Are they a loan? Are they not a loan? The law's going to actually codify that UPEs going forward are going to have to put on 10-year complying loan terms, which just again makes it harder to run like a trading business out of a trust where you need to retain working capital. Now that's probably all that we were going to go through, Tara. I'm not sure if there's any more questions.
That was fabulous. You both ought to be commended on making a difficult, complex area of law interesting. I think, Dan, as you said at the start, it's relatively simple, but still very complicated, even in the primary base case. That said, I think the message for whether you're a lawyer, a financial advisor, family lawyer, or an accountant, this is not a particularly sexy area of law, but just because it's boring doesn't mean we can ignore it. As sort of Lisa explained, the consequences of getting this wrong can be enormous in the estate administration phase. To me, I think it really just emphasises that there's a huge role of taking a holistic approach when it comes to estate planning. So if you're the lawyer, work with the accountant and make sure that this is on your checklist, that you ask the accountant, is there a Division 7A issue that could arise on debt? If you're the family lawyer or the estate planning lawyer and you don't specialise in tax, I think just at least be aware of it, have it on your checklist, and to get the accountant involved. If you're an accountant who doesn't do a lot in Division 7A, I think you need to obviously be able to identify these, but then know when to bring in experts like Daniel or Lisa for that tailored planning advice. But I really think we can't just stick our head in the sand and take the ostrich approach and go, oh, too complex, I don't like reading financial statements, I'm just going to ignore this, because as Lisa said, it doesn't really go away after someone dies.
And this is definitely an area that I is very interested in. I've been involved in a number of audits on Div 7A, and it's not something you can just ignore.
I have a question, which is, are there any particular type of client demographics where we're more likely to see this being an issue? Like in my mind, I think of boomer clients with a small to medium business with, trading companies or trading trusts. They usually, that's someone in that risk category where we need to make sure, as well as those like high net wealth family groups with multiple entities. Lisa or Daniel, any sort of demographics that you think are more likely to, or at least, just to try to like filter out when do you need to be on alert?
Well, I've seen it across all demographics. If there's a company in the group, that's potentially, Div 7A is potentially an issue.
Okay.
The trading trusts where they're using corporate beneficiaries, that is, if there's that structure, that has to be managed appropriately. It can be managed appropriately, but if it's not, that I see a lot of Div 7A issues in that case. The other cases, you've got a private company, mum and dad running a business, successful business, managing tax by just distributing out dividends to max out the lower tax rates, not going too high, but then just wanting to access the company funds for their own benefit. So, and just you can see that in the accounts, it just builds up these loans. There really is no demographic, Tara. I've seen it across all different types of demographics. If the company in the picture, Div 7A needs to be managed properly.
Okay, I like that rule. If there's a private company, you need to have it on your checklist.
100%.
Okay. So in terms of people who are going, okay, I might have some matters on my desk where there's private companies and I don't know. So if there are accountants or lawyers who need some support in this, is this something that Birchstone can do? Can you sort of help in the background or come in for a discrete issue?
Yeah, absolutely. We often work with other lawyers or often accountants as well on Div 7A issues, either proactively fixing stuff before they cause an issue, or trying to rectify stuff once they've identified an issue, or dealing with the ATO once they get involved. Obviously, the earlier the better. We can generally get better outcomes for the clients. So definitely reach out to Lisa or I, or if it's appropriate, post messages in the group, and happy to respond to any messages in the group if you want to do it on that basis. You can, I don't think our contact details, firm details are on the last page, so have a look at our website. Our contact details are both there, so feel free to reach out to either Lisa or I if we can be of assistance.
Fabulous. And just to confirm, you're based in Perth, but this is national legislation, so jurisdiction is no object, I imagine? No
issue at all.
Fabulous. Well, I think that's all the questions for now, and you've very generously given up a whole hour of your time, so I might let you go. There will be people who are watching this after the live. Daniel is in the group. Are you in the group as well, Lisa? If not, we might get you in there.
I am in the group, yeah.
Oh, fabulous. So you can tag Daniel or Lisa if you do have any questions and you're watching this after the fact. And on that note, though, I might let you get on with the rest of your day. Thank you so much for your very generous presentation. It's a complex topic, and I think you made it as simple as possible. So I'm very grateful for you both for your time today. We might finish up there. Have a great day, everybody.
Thanks, everyone. Thanks, Tara.
Thank you.
Bye.